I'm Richard Snowden. I'm a judge of the High Court in England. And we have today a stellar selection of panelists who I'll introduce very briefly to you. First to speak will be Phillips Qc, who is a long-standing member of South Square, probably the leading insolvency chambers in the UK. Mark has been practicing around the world in insolvency for many years, more than he and I care to remember. One of his colleagues at South Square is Mokal, who is also a professor at University College London, and again has been lecturing and speaking and appearing in court in recent years with increasing frequency. Outside the UK, Professor Christoph Paulus, who's from the Humboldt University in Berlin. It says retired. I can't believe, Christoph, you've ever retired. On the last occasion I met Christoph, I think, or one of the last occasions I met Christoph in person, I was cross-examining him across a courtroom, which we both enjoyed hugely.
Absolutely.
And finally, but not least, Professor Marta Flores, who's from the University of Madrid. Again, Marta is a regular participant, attendee at international insolvency conferences. So the topic we're going to talk about is Brexit from a European perspective. And I'm first going to ask Mark Phillips to set the scene.
Thank you very much, my lord. In January of 2020, the UK left the European Union and went into the transition period. During that period, the EU insolvency regulation and the recast Brussels regulation continued to apply to the UK as if we were a member state. Negotiations came to an end in December, and we turned to the 1,244-page Brexit deal. I expected to see agreement that in some way continued the insolvency regulation and the Brussels regulation in substance, or an agreement along the lines of the European Union giving effect to UK insolvencies under the Untitled Model Law, since the UK was and continues to give effect to EU insolvencies under the Model Law. To my surprise, there was nothing. In the insolvency and restructuring fields, we had a hard Brexit. I had been asked to prepare to comment on the impact of the agreement on those fields, and I sent back a 2-sentence email explaining that there was nothing to say. All I could do was hum Simon and Garfunkel's "Hello Silence My Old Friend" to myself. I was surprised, not least because there had been discussions and seminars about the best route forward post-Brexit. Amongst my colleagues in the world of international insolvency, the answer was clear. It was in the interests of all stakeholders in cross-border insolvencies to continue some form of recognition and cooperation. After all, that had been the profession's focus since the early 1990s, and the United Kingdom had played a central role in promoting the modified universalism on which it is based. So surely we would make sure that some system of cooperation would continue. But I was wrong. What I had thought was plainly right and not difficult hadn't even made it to the starting line. We had a hard Brexit. III, the ABI and the ABC has organised a series of 3 of these seminars in which we're going to look at Brexit from the perspective of Europe, North America and Asia. To some, it raises the question of enforcement of UK insolvencies. To some, it raises the question of whether the UK remains a good springboard for their insolvencies into Europe. To some, it raises the opportunity to compete for the UK's restructuring and financial market. Only yesterday, I read that 60% of senior bosses working across industries, including banking, asset management, hedge funds and private equity, now view New York as the top city for finance. Less than 1/3 now view London to be the world's main hub. 51% said that Brexit would weaken London's status as a powerhouse for financial services. If London is unable to offer restructuring services that will be recognised with ease across the EU, why should businesses have English law debt capital structures? The commercial imperatives result from and are dependent upon how the UK's insolvency and restructuring regimes fit in with the recognition process of the EU. For EU insolvencies coming into the UK, there's very little change. Under the cross-border insolvency regulations, the UK gives effect to the anti-trial model law, and whilst it is not automatic and an order from the court will be required, EU insolvencies should ordinarily be recognised in the UK. But the reverse is not the case. The UK is now a third country. In only 4 EU countries might UK insolvencies be recognised under UNCITRAL. That's Greece, Poland, Romania and Slovenia. They are the only countries to have given effect to the model law. However, their application cannot be inconsistent with the insolvency regulation. The position for UK insolvency practitioners seeking recognition and/or assistance in the courts of an EU member state is uncertain and unclear. One thing we know is that it will not simply be a question of turning back the clock and looking at local EU law before the insolvency regulation. The EU insolvency regulation will determine how member states deal with insolvencies falling within the regulation. The EU 27 will not recognise UK insolvency proceedings or determinations that are inconsistent with the determination of how a debtor's insolvency proceedings fall to be dealt with under the EU insolvency regulation. Now, if there was any doubt about the importance of recognition, you only need to look at Mr. Justice Zaccarola's judgment yesterday in Gate Group, in which it was made clear that if a scheme or arrangement will not be recognised, and I'm quoting, somewhere that matters, the English court will not sanction it. And that is bound to happen. So is the best solution interlocking arrangements with a Dutch arrangement or a German arrangement, the English arrangement to compromise the English law debt, the European to secure recognition across the EU 27? A key question will be the COMI. The EU 27 will continue to apply their COMI test. If they decide the COMI is in an EU country, that will then determine the extent to which they will recognise UK proceedings. What if the UK takes a different view? There is now a disconnect. While EU insolvencies continue to be recognised across the whole of Europe, including the United Kingdom, UK insolvencies do not enjoy the same privilege. The UK is no longer an easy stepping stone to the EU. So whose problem is this? The EU's, the UK's, or isn't it a problem? We will consider a number of issues, including what solutions are there under current legal systems? Should there be a bilateral treaty? And if so, on what basis? Should it be between the UK and the EU, or the UK and individual EU states? After all, we already have 4 states which have the UNCITRAL model law. Should the EU take the initiative? Should individual states take the initiative? What chance the UK taking the initiative, given that we learned today that Lord Frost, who negotiated the Brexit deal, which appeared to have forgotten our area entirely, has been put back in charge. We've been thrown into an uncertain time, which was quite unexpected. And on that, I hand back to my colleagues to tell us the answers.
Well, thank you, Mark. Well, is it all doom and gloom? Let's see whether everybody agrees with Mark. I should say, incidentally, as is usually the case, there's a chat function, so please feel free to use it. And I'll see if we can blend some of the questions into the panel discussion. I'm going to pick up some of Mark's questions first. So let me ask Christoph first. I mean, is there a problem, Christoph? And if there is a problem, whose is it? Is it the UK's, the EU's, or all of ours? All of ours?
That's a fantastic question, of course. First of all, I mean, it's a funny coincidence It's a dramatic appearance of two incidents. You are leaving the EU with this highly attractive instrument of a scheme, and we at the same time we are developing pre-insolvency restructuring frameworks. It is as if there were an invitation to get into competition or to fill the gap which has been torn by you guys leaving the EU 28. Given this, I would say the question of whose problem is it, it's a little bit biased from the question of that there is a competition among the various legal rules or instruments. And I had a conference 2 weeks ago in Austin, and that was exactly on legal competition. And we came to the conclusion that it's only a few countries who are participating in this competition. It is within the United States, the Southern District of New York, and now most recently it's the court in Houston, maybe Delaware to a certain degree. And then it is Singapore, of course, and it has so far been you guys from the UK. And the only one on the continent who are picking this up are the Dutch at the moment. If you look at the German instrument, it's purely domestic. There's no indication of any wish to come to participate in the competition. We are, how shall I put it, introverted, as it were. We are looking at how can we solve the problems of the German companies. So to the degree that this new German instrument develops, I would say from a German perspective, it's at least not the Germans, the problem of the Germans, that you guys are leaving. I might exclude a couple of companies who are eager to get the English scheme for several reasons. One of them, I hate to say that in your presence, dear my lord, but one of them is that you guys, you English judges, you are deemed to be just extraordinary. You're just great. You're fantastic. So that is one of the reasons why it's highly attractive for at least a number of companies to go over the channel. And for them, it's a problem. Generally speaking, however, I would answer the question. There is the major problem is on your side because you have so much concentrated on this kind of competition.
Okay, thanks, Christoph. Well, Marta, I mean, is it a competition or is it an opportunity or just a sadness?
Well, I think it's both. I mostly share Christoph's view, and I think on the face of it, it's mostly a UK problem. But now, actually, the UK restructuring tools are very popular for Spanish companies. So not being able to use them with the same legal certainty actually harms Spanish companies. So I think in this case, it's a lose-lose situation. But I agree with Christoph that it opens an opportunity for other countries which are implementing new restructuring tools. Now, Spain is not on that race. We have some restructuring tools implemented since 2014, and now there is a task force implementing the directive, but I doubt, maybe I'm wrong, but I doubt we will be competing in that race. So from a Spanish perspective, I think Spanish companies are going to lose.
So Riz, if it's seen as an English problem, but also I sense a feeling that the international collaborative community will suffer because there won't be perhaps the sense of collaboration which we've been fostering for some years. What sort of tools are available to the English courts and English practitioners to try and work more collaboratively perhaps with the European continent? Do we have any conventions, for example?
So you would already have heard mention of the Gate Group decision yesterday by Ms. Justice Zaccaroli concerning our new Part 26A restructuring plan, and that concerns the bankruptcy exclusion to the Lugano Convention, to which incidentally the UK is not currently party, and where the timeline for us becoming party is as yet uncertain. But Ms. Justice Zaccaroli's decision yesterday was that the nature of the RP is such that it falls in the bankruptcy exclusion to the Lugano Convention, with the result that if and when we were to sign up to the Lugano Convention, the restructuring plan would not be susceptible to recognition under the Lugano Convention. So that's one particular proceeding which is not capable of going down the Lugano Convention route. Of course, the possibility for schemes, the traditional Part 26 variety, to remain capable of recognition in Lugano, that is an open possibility. Nothing about yesterday's decision necessarily casts doubt on that. So if and when the UK were to sign up once again, that would be an option. Another option, a potentially powerful one, and one which has been sorely neglected the last few years, certainly since the referendum result and our a desire not to have the most devastating type of Brexit within our field, is to look at the domestic regimes of EU member states and indeed EEA member states. As the junior counsel to the company in the Gate Group matter, I was pleasantly surprised to discover that in the two key jurisdictions in relation to the Gate Group matter, Switzerland and Luxembourg, there are mechanisms within the domestic regimes which provide for an apparently ready and efficient way in which the restructuring plan could be given recognition as an insolvency proceeding. And we also have evidence from German colleagues that the same would be true in Germany as well, as an insolvency proceeding, the restructuring plan would be capable of getting recognition. Is it as good as the situation in which we found ourselves when we were still a member of the EU? Of course not. This goes back to the question you put to Marta. It is, in my view, a mutual disaster. It's a disaster for us in the UK in that we fall out of the automatic recognition regime of the insolvency framework within the EU. I would say it is also a disaster for other EU member states who have voted by their feet and by their pockets to move their commies to the UK, particularly but not exclusively to England, to make use of UK procedures, but much more importantly, to make use of UK practice, and including in particular the experience, expertise, and particular orientation of the judges in the UK who have dealt with this sort of matter, who have a particular orientation because of important and well-recognized sociological factors. It's a disaster to the extent that the opportunities for those European businesses who are in distress and who would otherwise have been able to make use of UK law, but more importantly, UK practice, not to be able to do that anymore, or if there are greater restrictions. But the fact remains that we need to make the best of the position which we find ourselves, and domestic recognition regimes are an underutilized and underappreciated resource.
Okay, well, thanks. So if we're trying to work to remedy the problems that Riz has identified, as well as domestic regimes in other EU countries or in EU countries, what about something like the UNTITLed model law? I mean, that's something in between, isn't it? Isn't that a widely available tool that could be adopted by EU member states, which would enable a degree of recognition, automatic recognition, to be given to judgments and restructurings, not just from the UK, but actually from all around the world, such as the US? I mean, what appetite is there in the EU, Christoph, for adoption of the Untertrial model law in the other EU member states?
Do you allow me that before I answer directly your question, I throw in something else, which I've read yesterday by a German commentator, which I find highly interesting. Mark was absolutely right in saying that this 1200 so much page volume doesn't contain a single word about restructuring. However, interestingly enough, it makes a reference to the mutual trust. And that is in Article 3 or something like that, at the very beginning. And it pleads, therefore, for the execution of this contract in the mutual trust or something like that. I don't have the exact wording in front of me. Nevertheless, this picks up on a concept which is also underlying the insolvency regulation. I mean, you all know it, that the most fundamental basement of the regulation is the trust. And here we have the treaty between the EU and the UK, based again on this trust, which is, in my understanding, to be understood exactly in the way how it is also underlying the regulation. I wonder if, I have no solution or no conclusion to draw from that. But I mean, after all, we are lawyers, and we might extract this trust element in combination with the Hartl decision of the CJAU. Just for the audience, I mean, of course, you know that all. But in that decision, the European Court said that the regulation does not apply just exclusively to the member states, but to the entire rest of the world. So there is a connecting link in the regulation to the rest of the world, including you guys. If you combine these two elements, the Hartl decision on the one side and the trust element, maybe we can build something on that. And I mean with we can build on something on that we should work together on that. So this is number one. Number two is your question. And that is the model law. Well, as a matter of fact, there is about to be published an article in German, in a German journal, in which I make exactly this proposal that the European Commission should enter into a treaty with the UK. And in order to overcome the lacuna which has been torn by Brexit, and now you are adding the interesting facet, if that should be extended to the rest of the world.
While you're pondering it, Christoph, let me, because we'll come back to the rest of the world in a moment, but let me ask Marta. I mean, it's a point that's been brought up by Robert Van Gelen in the chat.
Right.
Let's assume that the EU member states adopt or the Commission adopts the Untertrial model law. Does that only actually help the UK if the COMI of the company concerned is in the UK? Does it actually help any apart from that?
Well, we're coming to the interpretation of the COMI according to the model law, and we would need to determine whether this concept is equivalent to the COMI in the European Insolvency Regulation. And let me give you the question back. How do you in the UK interpret the concept of the COMI as far as the model law is related? Does it coincide with the interpretation of the European Court of Justice? Because I understand it is.
Yeah. Well, interestingly, whilst we were in the EU, the clear view of the Court of Appeal was that we ought to interpret COMI to mean the same thing in the cross-border insolvency regulations, the Untertrial model law, and in the EU insolvency regulation. I actually pointed out, I think, in a decision of mine called Videology, that might be up for grabs after we left the EU, and that's perhaps a case yet to be decided. But actually, I did point out in the Videology case that even if the COMI isn't in a particular foreign country such that recognition isn't automatic, it doesn't mean that one can't grant discretionary recognition under the unsettled model law. It's not a black-white. But of course, then that leaves open the prospect of a discretionary decision by a Spanish court to only grant discretionary recognition under the unsettled model law to the UK. So how do you see that playing out? Do you think Spanish judges would be happy to accept cases from the UK under the unsettled model law on either basis?
Well, the implementation of the model law is something that hasn't arisen in Spain. Actually, we have a national private law system, which is kind of similar to the model law. The requirements are pretty similar, and the judges are already given a discretion, and it's also based on the COMI. So I don't think Spanish judges would be dazzled by this approach.
So is the world moving then to a purely COMI-based system, Riz, or is there a view that the UK ought to perhaps give up its reliance on Gibbs, i.e. the importance of English law, or is there some benefit in maintaining certainty in financial transactions of having a known governing law that can't be, for restructuring of the debt, that can't be changed or misinterpreted on the basis of immovable COMI?
Let me make 2 points, Richard. One in relation to this question and the one that you put to Christoph and Marta. Starting with the latter, Christoph is absolutely right to point out that in frameworks such as that of the model law, and indeed that of the EU insolvency regulation, trust is crucial. Christoph focused implicitly, it seems to me, on the trust between different member states who are party to that framework. And a receiving court must have a degree of trust in the quality of the proceeding which it is asked to recognize. And in the absence of that trust, it becomes very difficult to operate that system. I think that's absolutely right. There's another type of trust, however, which is a system's trust in its own practitioners and judges. And talking to European friends, including those within the EU, but also within the wider EEA, my sense is that there is an absence of trust in many European jurisdictions in their own judges, that there is a reluctance to vest too much, within quotation marks, discretion of the sort which is part and parcel of the functioning of the model law in the judges of that system. So this domestic, inward-looking trust is lacking, and I'm interested to see Marta's point about how something like that discretion might already be envisaged within the Spanish domestic regime. Turning to the second point, so that's my sort of criticism of European friends and colleagues. Turning to criticism of the English approach to Gibbs, it seems to me that this is outmoded, it is hypocritical, it is inconsistent with the English court's own arrogation of jurisdiction to rewrite debt governed by other legal systems. My late colleague and friend Ian Fletcher, who was most mild-mannered and measured person you could imagine as a scholar, when I read the ferocity with which he condemned the English system's adherence to Gibbs, it was completely out of character in one sense, but it was just such a stark departure from the principle of universalism that English law and English courts have led the world on, that it just becomes increasingly difficult to maintain our adherence to the system. As Mr. Justice Ramesh Kanan's judgment in the Andy-specific case in Singapore shows, and then Justice Marty Glenn's judgment in the US and Ecrico shows, we are going to be outside of the consensus of the community of collaborative insolvency and restructuring professionals the longer we adhere to Gibbs. This is not the way to guard our territory, in my view.
Christoph, did you want to say something on that?
Just a tiny little word adding to this. The Gibbs rule might be the killer for in the future, at least to the degree that there is a jurisdiction which is dependent on reciprocity. I mean, if you are working on the basis of reciprocity, then I can easily imagine a number of judges who are saying, no, if they wouldn't accept ours, we do not accept theirs. So, I mean, we must not forget that we are not talking about high, well, how shall I put it? We are dealing with people, and some people are more sophisticated than the others. And you must understand that on the continent, it is still seen as a kind of nasty divorce that we have behind us. Of course, we adored you, and now you left, and that is, I mean, that is painful for some. And there is this kind of how very anthropological behavior of, well, they left, and why should we give in something? And that is a perfect hook, so to speak, to jump in and to say, well, if reciprocity, if they don't accept my decision, I won't accept theirs. You have to turn on the microphone.
I'm sorry, just drawing. So let me suggest one thing, though. I mean, both you and Riz have seen this in terms of a sort of black-white. It's either Comey or Gibbs. I mean, can we look at it maybe, Marta, from a slightly different perspective? I mean, true, Comey is very meaningful where you have a trading company, say, for example, of the type which is found in great numbers all around the world. But if you have a finance company, which is purely set up for the purpose of acting as a banker for an international group, where its Comey is based is really a matter of pure happenstance. It could be moved very easily, and you can have some pretty bad forum shopping, or some good forum shopping by trying to move the Comey. Well, why shouldn't the governing law of a financing instrument be an appropriate basis for assuming jurisdiction to restructure that financing debt? Because there's certainty then for the people who are investing the debt in the first place. They know exactly how it's going to be altered, by whom, and under what conditions, and they know for sure it's not going to be subject to some last-minute Comey shift. Is there a possibility of using both tools?
I think this is a very interesting approach, a very interesting proposal. The thing is, the governing law approach leaves the determination of the jurisdiction entirely to the will of the parties. It promotes the freedom, the role of the parties when determining which jurisdiction should be competent over their debt. Now, the Comey has a more institutional approach in the sense that, in principle, it aims at protecting somehow the interests of third parties. This is why the Comey ought to be recognizable, ascertainable by third parties. Now, I fear, while I think this proposal is interesting, I fear that an approach which is strictly based on the governing law might be less protective for the interests of third parties involved, not creditors, but other stakeholders. So this is my criticism to this approach.
Okay, but let me ask you, Riz, how if we go to Comey as the main foundation for jurisdiction, what happens if courts in different countries, say an EU country and the UK, take a different view about where the Comey is? Because it's a very multifactorial question. It's a judgment. I mean, the governing law is straight. I mean, there it is. It's effectively a contractual choice by the relevant people. Very straightforward. Whereas Comey is up to judges to decide, well, what happens if we choose something that can be differently interpreted in different jurisdictions? Isn't that a recipe for disaster and uncertainty when we need collaboration, cooperation?
Richard, three very quick points. The first point is, in relation to stakeholders who are able and willing to move COMI, I think it's a for sure that they would be able and certainly willing to change the governing debt as well. So I doubt that governing debt provides greater stability and the ability to predict than does COMI. That's the first point. The second point is that the problem with Gibbs is not, in my view, that it provides that the English law mechanisms for rewriting English law are available. I think that's unobjectionable. The problem with Gibbs is that if it's English law governed debt, only English courts can rewrite the English law governed debt. So it's the exclusivity built into the rule in Gibbs, which is the problem. The fact that the governing law mechanisms remain a possible way of rewriting that debt seems to me to be not just unobjectionable, but positively healthy. So I'm very much in favor of the non-black or white approach. And the third point is the one that you mentioned. It is a live issue and part of the disaster to which I adverted, that now fights about the location of the COMI and the effectiveness of the shift of COMI, which were much less realistic given the history of that question as developed while we were still part of the EU. Those fights are now a live issue. And of course, as far as the European Union is concerned, and presumably also the EEA is concerned, if the English court determines that the COMI lies in England, but any EU/EEA court takes a different view, I'm not placing bets on the English court's decision prevailing, which is a great shame because contrary to what some have said on the continent about the English court's determination, I think there's always been a search for rigor about applying criteria properly in the way in which COMI is intended to be utilized in the English courts. And so it's a great shame now that the determination by the English court that it is the COMI court is no longer going to be necessarily going to be respected by EU and EEA jurisdiction courts.
Although presumably the extent to which there's trust and confidence in the judiciary will improve the prospects of recognition. But there's an interesting question. Stefan Marius has asked, it's another interesting possibility. What about having a sort of blended approach? Gibbs, if what you're trying to do is to modify debt, but COMI for the procedures of distribution of assets. In other words, if you're looking to protect the people that Marta was talking about, the stakeholders, that's usually done through a process of distribution of assets in a fair and appropriate way. But if all you're looking to do is actually modify debt, which can be provided by, say, financial institutions, what about being able to use Gibbs for that purpose? Whereas
I think there's the same ambiguity to which I pointed a minute ago, which is Gibbs is being used, it seems to me, as shorthand for the courts of the law governing the debt. I think that it is, in my view, unambiguously a good thing for the courts of the jurisdiction whose law governs the debt to be able to restructure that debt. But that's not Gibbs. Gibbs is that if the debt is governed by English law, then only English courts can restructure. And if that is the approach taken towards Gibbs, then there is no possibility of having the blended approach to which Stefan points.
But is that, hang on, Riz, is that actually what happens in practice? Because for many years we've had parallel schemes, certainly in the common law jurisdictions, where you do a scheme. And Mark mentioned this in his opening. You do a scheme in the place of incorporation or where the COMI is, and you do a scheme in the place where the governing law of the debt is. And you do it in parallel, so you get the best of both worlds. I mean, is there a future for this? For example, let's say you've got a Dutch finance vehicle incorporated in the Netherlands for tax reasons, doubtless as many are. rather than going through a sort of slightly farcical change of the COMI to nail up a plate in a room in London, why not just do a parallel plan, parallel scheme in the UK for English law governed debt and in the Netherlands in order to get recognition throughout the rest of the EU? I mean, is there a future for that?
So there are three problems that I see. In principle, to the extent to which something like this was considered appropriate and useful for the by the stakeholders, I would be very much in favor. The three challenges are as follows, it seems to me. One is expense. Anybody who has experience of restructurings in this jurisdiction or elsewhere in most common law jurisdictions would know that it tends not to be the cheapest of processes. So if you now have the additional expense of having a duplicate process in a different jurisdiction, in some cases that would be fine and that's great. In many other cases, which are marginal, it may have been possible for the expense to have been borne in one jurisdiction, but with the added expense of having a parallel scheme in a different one, the restructuring becomes impracticable. That's one problem. The second is the one to which you referred, Richard, which is trust amongst the courts, amongst the judiciary. To the extent to which there is spirit of cooperation and trust amongst the judges, that's brilliant and again, unambiguously a good thing. Query whether there will be many courts with that sort of trust in themselves as well as with courts with whom they are asked to cooperate and to operate in tandem in relation to those schemes. And the third would be the degree to which having to operate in tandem in different jurisdictions creates further opportunities for free riding and for holdout scenarios. So the greater the moving parts within a restructuring, the greater the potential for free riding and holdouts.
Okay, well, so Christoph, I mean, Riz obviously sees a lot of potential issues with the dual approach that I was suggesting. How do you see cooperation between courts from a German perspective? I mean, is there a way in which court cooperation in this sort of field could be enhanced?
Certainly, yes, at least from a theoretical point of view. But let me first come back to the question that you have posed to Riz. I mean, we know this situation both ways. We have, because that is also one of the questions from the audience. We had most recently, 2 years ago, a case, the Air Berlin case, and you have it now in England in another context, in which there was a dispute between the Berlin court and the court in Austria. And it was, as you have said, Richard, that the courts counted the elements which were speaking in favor of Berlin and counted in favor of that. I mean, that is the inherent wrongness of the COMI approach, at least how it is interpreted right now. Having said this, we have, on the other hand, we have another case. If the English court decides or sees a different place as the COMI than a continental one, then you have the situation of the Maxwell case in '91 or when it was. I mean, then you have the disaster of two main proceedings opened, and we know what came out of it. And then the solution is, as you indicate, and here I come to your question, then you have to communicate. And once again, don't forget that, I mean, for you, it's your mother tongue. For the rest of the continent, it's minimum the second language. To speak English, I mean, communication usually is in English. If you have to use an interpreter, things are getting complicated. So communication for you guys seems like the most natural thing. And I would say, I fully agree, it's fantastic, it's good, and it's, I mean, it's a huge progress in at least German legislation, and we have it all over Europe now, thanks to the regulation, that the courts are obliged to communicate with each other. But this is the law in the books. The law in action is, that's what I hear, Again and again, that is something which is written in the books and not practiced, because there is this language problem. And it's extremely hard for every one of us to say, particularly when you're a judge, a recognized judge in a small village or even in Berlin, to say, yes, I'm the big judge, but unfortunately I can't talk with a judge in Poland because he doesn't speak English. Incidentally, I don't speak either. So there is a huge language problem.
I mean, and Marta, I mean, is that the biggest obstacle? I mean, is there another cultural obstacle to a European civil law judge communicating with a judge, say, in the US? Let's take it out of England just for a second. I mean, would there be any circumstance in which that sort of thing would occur?
Well, I'd like to give a broader answer, because related to the cooperation, not only between courts, but also between insolvency practitioners, maybe when we're talking about the insolvencies of different companies that belong to the same group, or to different proceedings, main proceedings and secondary proceedings related to the same debtor. The European regulation specifies cooperation and communication duties between courts and between insolvency practitioners and between insolvency practitioners and courts. Now, now that the European insolvency regulation is no longer applicable, maybe it's time to explore, in order to enhance those cooperation duties, communication duties, and to solve any problems, just as language, as Christoph pointed out, that may arise in practice. It might be useful to resort to contractual instruments such as protocols, which are specifically mentioned in the European regulation and which have been used in practice precisely to cooperate proceedings all over the world. And now we are finishing a research project funded by the European Commission. I see Stefan Madaus is here. And one of the tasks that we carried out inside this research project at the very beginning was to conduct an empirical study among judges, and we asked them whether they will be willing to enter into a protocol with a foreign court or with a foreign insolvency practitioner. Now, the answer, when the foreign insolvency practitioner or court was within the EU, was a big yes. More than 90% of the respondents asked yes, we would be willing to enter into a protocol with another EU judge or a EU insolvency practitioner. Now, when we asked the same question, but with regard to a country outside the EU, the number of yes dropped to 50%. We missed a golden opportunity to ask the same question with regard to the UK, because I believe that, and this is a mere speculation, but I would believe that if we had asked that question, the answers, the willingness to enter into a protocol with a foreign court, with a foreign insolvency practitioner, would be closer to 90% than to 50% in the case of UK practitioners. This is and this relates to the mutual trust that we were talking about, and to the fact that why should we find a solution with regard to the UK, because it's the most pressing problem we have now because of the intertanglement of our economies.
So, I mean, there are a number of points to pick up from what you just said, Marta. I mean, obviously, first of all, there's the use of protocols, which are usually or can be coupled with some court-to-court communication protocol. And there are the GIN guidelines that have been promulgated. You know, the initiative of Singapore a few years ago. There's the US American Bankruptcy Institute guidelines. There's the EU guidelines. There's plenty of tools out there. Is it a willingness or a lack of education about their availability, or just an unwillingness to use those tools to communicate? And would it be helped if, as you say, you had perhaps an international firm of accountants that was involved acting as a go-between courts? Would that make life easier? Because these organizations operate internationally. I mean, could they be used as a conduit to make life easier on a linguistic or just personal level?
Well, actually, as a result of the empirical study we conducted in Spain, the judges we interviewed, all of them pointed out that they lacked resources to communicate, to liaise with all the foreign courts, and they were asking, as you point out, as some sort of organism that may help us, help them do that. And but this again, the protocol solution between courts is also a tricky thing, because it may affect to the independence of the courts. So it's not so easy.
And that goes back to perhaps confidence in the judiciary, which I think a number of people have spoken about. What about changes to other things? What about, for example, one of the questions that's again in the chat from Kat Berg is, what about taking groups and determining COMI on an enterprise level? I mean, is that easier? Is that more difficult? Does that provide some sort of solution, or does that just run us into the same sort of problems we have with doing it on a company by company level?
So I think you have to look at, so I'm not a huge fan of COMI in case I gave anybody that impression. The problem with COMI is that it is difficult to strike a balance between two extremes. On the one hand, you could look at it in terms of predictability. You look at primary factors which tend to outweigh secondary factors in the determination of COMI. So, for example, the top level decision-making as ascertainable to stakeholders and other third parties. But if you take that, that's ascertainable, that's easy. You could do it at a group level, or you could do it at an enterprise level. The same conclusion would be, the more superficial the approach to determining COMI, the easier it is to determine from the outsider's perspective, but easier it is to shift, thereby defeating any expectations about where the enterprise would have been dealt with in its insolvency. By contrast, if you go too deep and you look at the balance of all of the factors, you end up either having a counting exercise where 6 elements are located in Germany and 7 are located in Austria, so Austria wins, and or you leave it completely unclear ex ante from the stakeholders' perspective how to strike that balance amongst dozens of factors, each of which has to be weighed in the scales in order to determine where COMI lies. That tends to defeat the purpose of having COMI, which is to enable stakeholders and other third parties to know with certainty where the debtor is going to be dealt with in its insolvency. So COMI is not a panacea. And I would say, I always come back to thinking about how it said that a book which enables you to spot a forgery is also a guide to creating a good forgery. So any formalistic way of predicting where an insolvency is going to happen is going to be also a way of changing where an insolvency is going to happen, as the point about COMI and indeed the point about governing law shows. So we have to think about substance rather than form. We have to think about the principles underlying good as opposed to bad forum shopping, and that's where the focus needs to lie. Otherwise, it's chimera. It's illusions about how we can pin down where insolvency is going to occur. Well, sufficiently resourceful and imaginative stakeholders will go their own way.
Okay, so let's try and round up a little bit of the debate. We may be able to take some more questions. Actually, I will ask Lucy's Mitchell-Fry's question straight away, because it follows on from what you said and it had occurred to me. I mean, if you're not an out-and-out devotee of COMI, but you're plainly, fairly plainly not that entranced by Gibbs either, although I did sense a sort of element of the ghost of Gibbs coming back into the debate in the last answers. What do you think judges should use to determine jurisdiction? Is it really just a sufficient connection, as the judges have decided? And how does that sort of flexible test play out in the common law world, where judges are used to exercising quite a lot of discretion, or in the civil law world, where I suspect Christoph and Marta may tell us there's slightly less flexibility usually wielded by the judges? Let's start with you, Riz. Quick sort of question or quick answer. What's the test?
Sufficient connection plus the principles underlying good forum shopping are as good a place to start as any other, and possibly better than both governing law and COMI.
So how does that go down in Germany then, Christoph?
You're not saying to me that it shall be a short answer. And for that reason, I take the liberty to speak a little bit longer. My dear friends from the South Korea, they should have read in the South Korea Digest, where I made the proposal that in order to overcome these difficulties with the COMI and this counting, I mean, it reminds me of a soccer game, and with a penalty kick in the end. I made the proposal that there should be a competence of the, let's say, the Supreme Court of Estonia or of Portugal, or I don't know what, which country, which decides that within, let's say, 2 weeks or 3 weeks, obliged to do so by a EU regulation or whatever, to decide in a particular case where the COMI is. So that it would solve the problem of, it would not solve the problem of predictability. It would choose between options, and these options are submitted by the parties. So insofar there is a certain openness, but it's a restricted openness. And it is something where you have safeguards for the third parties, for the creditors. So that was my solution submitted in an English journal.
And Marta, any solution from Spain? How do you see, is it any of the options you've just been presented with?
Well, from a Spanish perspective, Spanish judges will recognize foreign jurisdiction if it's based on the COMI or an equivalent connection. By equivalent connection, it is peacefully agreed that a registered office and the presence or the existence of an establishment, but the significant the governing law and this kind of connections are out of the. I think they pose a risk with regard to the recognition in Spain.
Okay, so let's try and again sweep up a few loose ends. I mean, is there a future for cooperation in Europe, and or is the current situation one of a sort of retreat to national borders, retreat to nationalism? I mean, is there a future for us all? Riz?
It's more important than ever for us to emphasize and focus on cooperation. It's more important because of the problems that we British have created through this Brexit, and it is essential within our community for the benefit of all of the stakeholders, without any exception, for cooperation to occur at the level of practitioners, both legal and accountancy, and very much at the level of judges. That is something we can do something about, even if we can't do anything about the broader political trends as we have seen the last few years.
Good. So moving, Christoph?
Fully agree. I mean, but it's indicative. I mean, you asked the question, do we? And Riz was answering, we should. And I fully agree with the should. The question of the do we is much harder to answer, because I'm afraid that right now the COVID pandemic is creating a lot of disaster and a lot of damage to internationality. I mean, if you look at the supply chains, the discussion about supply chains, then that we should produce more on a national level in order not to be entirely dependent. it remains to be seen. I mean, it's the most stupid answer you can give, and I do it right now. But I'm afraid that the COVID pandemic is creating a lot of damage in terms of internationality.
So Marta, I mean, is there a group of people, or is there a way that we can, well, sorry, I should ask you, first of all, is this a retreat to nationalism? And if that's something you think is bad, how should we go about it? Is there a group of people or few groups of people who can provide us with the answer?
Well, I think indeed we're facing a retreat to national borders. I also think it is understandable, an understandable reaction given the circumstances, and Christoph pointed that before. It's we're witnessing it right now with the pandemic. But I think the crucial issue here is to understand or to be aware of the fact that if everybody looks at their own belly button, as we say in Spain, then it's going to be a lose-lose situation. So in times like this, more than ever, we should leave aside nationalist perspectives and face problems from a global approach. But I don't have a solution.
No, but I mean, is there a group of international practitioners? Is there a group of judges? I mean, how do we go about facilitating the dialogue? I mean, I'll answer my own question in a way, which is, I mean, there are international judicial initiatives to have judges. There always have been, to have judges in different countries talking to each other, both at international conferences to do with their respective areas of law, and insolvency is one of the preeminent areas where judges talk internationally to other judges. What about the practitioners? I mean, are there groups of sufficiently well-developed groups of insolvency practitioners in the European Union who can take up the initiative to correspond and to talk with the UK and indeed the wider world?
Well, there are associations at the European level of insolvency practitioners, but the problem with those expert groups is that the work is very slow, and now I think we need a solution right away. It's a pressing problem, in my opinion.
Okay, well, if anybody has an answer to the question I've just posed, we've put it in the chat right now. Hands up the volunteers to lead the charge. But in the absence of any immediate questions or answers on the point, I'm going to turn it back to Mark as a leading practitioner. How do you see, have you been cheered up, Mark, given that you came into this all gloom and doom? Is there a future for you?
I'm just realistic. I was very, very cheered up until Christoph reminded us about penalty kicks, which I thought was extremely unfair from a German. We are all talking in the sense that, you know, we are here in amongst the III group, and I know that lots of UK practitioners are talking to each other. It's not easy because of COVID. And here we all are, none of us, I suspect, are in the same room. We're not able to meet at conferences in the way that we used to and sort of go to a side and chat and say, what's your take on this? So it has to be much more, in this sense, it's much more formal. But I do think there's a lot of practitioner goodwill. I have a number of wrap-up points. I don't know whether you want me to take it from there.
Yeah, fire away.
Okay.
I'll wait for the questions coming in the chat.
Yeah, I mean, I'm not entirely doom and gloom, but what I am disappointed about is that what we've just tried to do is we've tried to encapsulate 30 years of discussion amongst practitioners across the insolvency world into an hour, having given ourselves a major problem. And it's very disappointing that having reached a particular landing spot internationally, we then altered where we were quite dramatically through Brexit. Number of points coming out of it is I've heard from the panel that it is a major problem from London, but it's actually heartening, and I know this may sound odd in one sense, it's heartening to hear, you know, Marta describing it as also a major problem for other countries who want to use the UK's restructuring expertise, and more than once it was described as a most pressing problem. And I also picked up that Professor Wessels, who everybody knows very well, you know, said that he doesn't want this to become a competition between countries and jurisdictions, which is as an approach is obviously extremely heartening. This competition between different jurisdictions is not something that the practitioners ever asked for. We were all doing something very different. So that again is heartening. I also think it's heartening that listening to Riz, who's just looked at it in some detail, that domestic laws do give us some possibilities. It's plainly not as good as where we were, but it does give us some possibilities. And I also found it heartening that Christoph referred to the element of trust. And when I was listening, that you find in the Brexit agreement, which I hadn't personally picked up. And it's also, it brings to mind, obviously, the comity concept at the heart of all international conflict areas. One idea that I've got that really comes out to me is that we need to try to persuade our governments to adopt an agreement, and I think based on the model law, or we may even get as far as persuading the EU to adopt the model law generally, because that will obviously facilitate the US and other jurisdictions. But from an immediate point of view, the possibility that we can persuade the EU and the UK governments to enter into an agreement between us whereby the EU will adopt the model law as regards UK insolvencies, I think that is very good, but as a possibility, it is going to require all of us to speak to our governments. Yeah, Christoph, because I know you've written about this.
Apologies. At this point, can I ask a question? It's certainly a very stupid one, but nevertheless, it bothered me a little bit. You have this section 426, and all what it says is relevant. And you understand relevant as being the Commonwealth. Couldn't you have a 426A in which you have relevant to, and these are all the EU 27, and then make something out of it?
But if the EU 27 would sign up to that, that would be great. I mean, we've adopted the UNTITLed model law unilaterally, so anybody can use the UNTITLed model law, as Mark pointed out. Okay.
Yeah, so, and Christoph, I completely agree, because 426 is a leftover from our colonial days.
Sure.
And continuing 426 appears to ignore the fact that we are no longer a colonial power. But I think some in the current government probably think it would be a good thing if we were, but I'll put that to one side. The other possibility, which is a technical one, I like to be a bit controversial, you know that. The other possibility, of course, the practical possibility, is the use of parallel schemes, but it's in one sense disheartening that, you know, Riz identified a number of problems, costs and holdouts, and one can see that, but there may be no realistic option but then to go down that route.
I have to say, I mean, I didn't respond to Riz at the time.
Yeah.
I mean, the cost of the court process in two jurisdictions, I would have thought, is insignificant compared to the restructuring fees and costs, which will be incurred in any event, and they've got nothing to do with the court process, actually. So I wonder whether that is really the case. And then the question of holdouts or disconnect between parallel jurisdictions is one that is solved by courts having the confidence to talk to each other, or just the confidence in each other. All the parallel schemes that were done in other jurisdictions, the UK, Singapore, Hong Kong, the Cayman Islands, where the common law world, have worked perfectly well without anybody trying to arbitrage one jurisdiction against the other. Doesn't it all go back to cooperation again? Sorry, I throw that in.
Absolutely, and but personally, I completely agree, which in a sense brings me back to the final point, and that is this question of nationalism. And I think it's very difficult for all of us as internationalists. Many of us would probably have favoured even more universalism than we saw through the modified universalism approach. That to many of us since the 1990s was, if you like, obvious. And it was something that we all believed that we could strive towards, that we could break down the barriers between the various jurisdictions operating in insolvency. What I personally have found very difficult to get my head around is that in recent years, and we've seen this illustrated by Brexit, we've seen it through the MAGA movement and Donald Trump in the States, we saw it recently to a certain extent through the COVID vaccine supply, is this increased nationalism politically around the world. And it may be as a hope, that we aren't going to be out of the mainstream for too much longer, because it may be that everyone is beginning to see that a more internationalist approach is good, and it may be that there will be a rebalancing back to what, to me, is obviously in everyone's interests, and maybe that will move back to the centre of the debate. In the meantime, and we have really got to get a move on this, we have now got a situation post-Brexit where we don't have the insolvency regulation, we don't have the Brussels regulation, and something has got to step up soon. We really have got to get the politicians to step up and give us something soon.
Right, well, time is marching on. Thank you, Mark, for pulling that together. We've come to the end of our time at 1:15. Can I first of all thank, on behalf of everybody, the panelists, Mark, Christoph, Ritz and Marta. I think I probably ought to thank all of you for giving questions, and also to the sponsors, obviously the International Insolvency Institute, the American College of Bankruptcy and the American Bankruptcy Institute. Thank you all very much. There will be another one of these, second in the series, to be chaired by Chris Sonshi from the US Bankruptcy Court on February the 24th. So hopefully to see most of you then. Thank you very much.
Thank you very much, everybody. Thank you.